Notwithstanding his relocation to California with his spouse, Meghan Markle, in 2020, Prince Harry recently expressed in court that it was not his decision to leave. In an official statement presented before a London court, the Duke of Sussex stated the importance of the UK in preserving the heritage of his children and his strong desire for them to experience a sense of belonging in the country. He argued that the safety of his family on British soil is his priority, and emphasized the potential risks to himself and his wife without adequate protection. During a High Court hearing, Prince Harry expressed that his children, Archie and Lilibet, cannot truly feel at home in the UK if ensuring their safety is not feasible. The written statement, presented at the end of the 3-day hearing challenging the decision to revoke his automatic security, delves into the complexities of the Duke's departure from the royal family. Notably, Prince Harry did not personally attend the court proceedings, but his legal team passionately advocated on his behalf. The Duke of Sussex elaborated on the circumstances that led to his relocation to the United States, stating that he and Meghan felt forced to distance themselves from the royal family, causing them profound sadness. His barrister expressed to the court that their decision to move was not merely a matter of choice as popularly assumed, but a response to circumstances that compelled them to take such a drastic step. Much of the legal proceedings were conducted in private, owing to confidentiality concerns surrounding security details and protocols. The major point of Prince Harry's argument is his disagreement with the decision to strip him of police protection. He said it was flawed, unjust, and unreasonable. His legal team urged the court, specifically riveting, the entity responsible for determining royal security, to reconsider its decision and reinstate the security measures. The Home Office maintains that the decision was appropriately made, emphasizing that Prince Harry, no longer a working royal, should not receive security treatment equivalent to that of the reigning monarch and other senior members of the royal family. This is in accordance with the statement made by Unveiled that Prince Harry is currently constitutionally irrelevant. Moreover, Prince Harry challenged the narrative that portrayed his departure from the UK as a voluntary choice, asserting in his witness statement that it was a source of great sadness for both him and Meghan to feel compelled to step back from their roles and leave the country in 2020. This revelation challenges the earlier perception that their decision to distance themselves from royal duties was a joint and voluntary one. Notably, royal expert Omid Scobie suggested that external support, particularly from family members, might have influenced their decision differently. "The UK is my home, and the UK is central to the heritage of my children. It is a place I want them to feel at home as much as where they live in the United States. That cannot happen if it is not possible to keep them safe when they are on UK soil. I cannot put my wife in danger like that, and given my experiences in life, I am reluctant to unnecessarily put myself in harm's way too." Prince Harry's emphatic words not only express his frustration, but also provide a poignant glimpse into the challenges faced by his family, seemingly torn between a desire to visit the UK and the seeming obstacles preventing them from doing so. In response to the denial of automatic police protection for himself and his family during their visits to the UK, the Duke of Sussex initiated a legal challenge against the Home Office. This legal battle stems from the decision of the Executive Committee for the Protection of Royalty and Public Figures in February 2020, which deemed that Prince Harry and his family were no longer entitled to the same level of personal security when on British soil. The ongoing proceedings have been presented before Mr. Justice Lane as Prince Harry seeks a judicial review of the decision. A potential complication in this legal challenge has arisen with the Home Office contending that Prince Harry has delayed bringing his case to court. Sir James Eadie KC, representing the Home Office, has hinted at the notion that the committee's decision might be a consequence of Prince Harry's voluntary choice to step back from full-time royal duties. This insinuation raises questions about the relevance of the Duke's decision to the committee's determination regarding his security. Miss Fatima, Prince Harry's barrister, vehemently disagreed with this, arguing that her client does not accept that leaving full-time royal duties was a voluntary choice. She urged that the committee's decision should not be framed as a consequence of a personal choice made by the Duke. Her argument aimed to clarify the nature of Prince Harry's departure from traditional royal responsibilities, as not a matter of choice but rather a response to circumstances that compelled the Duke and Duchess of Sussex to make a significant life-altering decision. The legal proceedings, at their core, highlight the nuanced nature of the Duke's relationship with the UK and the royal responsibilities he left behind. The frustration evident in Prince Harry's words reflects the challenges faced by the family, who, despite their willingness to visit the UK, find themselves entangled in a legal dispute over their security entitlements. As the legal battle unfolds, it delves into not only the technicalities of the security decision, but also the broader societal implications. The timing of Prince Harry's legal action is brought into question, adding a layer of complexity to the proceedings. Miss Fatima, the barrister representing Prince Harry, has firmly expressed to the judge that her client has been unfairly treated, having been singled out for less favorable treatment compared to others. According to her, the Duke of Sussex has been subjected to treatment that is both unlawful and unfair, framing the legal challenge as a response to the perceived injustices he has faced. The crux of Miss Fatima's argument lies in the committee's failure to take into account the potential impact on the UK's reputation in the event of a successful attack on Prince Harry. She emphasized that considering his status, background, and profile within the royal family is necessary in assessing the gravity of such a situation. In this context, Miss Fatima pointed out that the royal household, in its own correspondence, raised the specter of Princess Diana's death, indicating that the committee was fully aware of the broader implications of any attack on her younger son. Sir James, representing the Home Office, defended the committee's actions, describing their approach as bespoke. He explained that the committee adopted a tailored strategy for the Duke's security, evaluating each visit on its individual merits. Sir James argued that a conventional risk analysis, typically conducted for other VIPs, was deemed insufficient in this unique case. The unpredictability of the Duke's visits, with uncertain durations and activities, posed challenges in accurately assessing the potential impact and vulnerability to an attack. Miss Fatima countered this argument, stating that the Risk Management Board's analysis was a crucial component of the committee's decision-making process. She emphasized the importance of obtaining an R&B analysis as the initial step, challenging the committee's deviation from its own policy. According to Miss Fatima, Prince Harry's case is exceptional and unprecedented, representing the first instance where the committee has strayed from its established policy without providing clear or cogent reasons for doing so. Highlighting the legal enforceability of the committee's policies, Miss Fatima argued that any departure from the established framework should be highly scrutinized, especially when significant stakes are involved. The barrister argued that the committee's nuanced approach, while defended by Sir James as appropriate and reasonable, lacked clarity and presented questions about its deviation from established policies. In written submissions, the Home Office's barrister acknowledged the limited nature of public resources allocated to state-provided protective security. He argued that it was plainly rational for the committee to consider Prince Harry's stepping back as a working member of the royal family when allocating these resources. The judge will ultimately decide the merits of these arguments, with a final judgment expected at a later date. Adding complexity to the legal saga, Buckingham Palace previously acknowledged being blindsided by Prince Harry and Meghan Markle's decision to step back from their royal duties. While recognizing the couple's desire for a different approach, the palace emphasized the time required to address the complex issues involved. In February 2021, Harry and Markle formally resigned from all royal duties, while reiterating their commitment to serving the UK and the world, pledging continued support to the organizations they had represented. Following their decision to step back from royal duties, Prince Harry and Meghan Markle faced repercussions. King Charles III evicted them from Frogmore Cottage, reallocating the royal residence to Prince Andrew. As non-working royals, they also lost their security privileges, raising concerns for Harry about his family's safety during visits to the UK. In a January 2022 petition, Harry drew attention to documented neo-Nazi and extremist threats against his family. To address security concerns, he offered to personally cover the costs of private security, alleviating the financial burden on British taxpayers. While certain critics have expressed their suspicion that the prince's current quest to regain his tax-funded security detail is due to the exorbitant cost of paying for security personally, the decision on Harry's security case is pending, with an expected resolution at a later date.